let's continue with the bribery and the corruption chapter. I just want to highlight that there are still many of you who haven't typed your names yet in the chat room. So for many of you, I cannot consider you as attendees. You haven't attended yet until you type your names, please. Or open the mic and speak if you could not type your names. So let's continue. We have looked at the Bribery Act of 2010, the UK Bribery Act of 2010. And now we shall look at the US Foreign Corrupt Practices Act, sometimes called the FCPA of 1977. You'll notice that this is way older than the UK Bribery Act, but once we start covering this, you'll notice that the UK Bribery Act is more strict. So who does this law? So let me just put it here, the USA US FCPA. The act applies to US citizens, anybody who lives in the US, any company listed in the US, any foreign firms and persons while in the US. So you'll notice that the UK Bribery Act, first and foremost, is way more far-reaching than the US law. The UK law, it's basically, you don't even need to be in the UK, and they just need to prove that you have a close connection to that person in the UK, and then you fall under the law. In the US, no. You'll notice here that you should be either a US citizen or you can be a foreign person, but you are in the US. The core components of this law, it can be payment for any value. There is no lower limit. So as little as 1 cent, you are prone to bribery. Worldwide scope. So this basically means it's not just people who are receiving the bribe or paying the bribe in the US, but also people from outside the world. There must be an intent, like in the previous case, there must be an intent that you are receiving this bribe in order to perform a certain operation or a certain action for somebody. Offense to pay bribe to foreign official, political party, or a politician. It is an offense to pay an intermediary if known that the payment will be used as a bribe. So even if you've not bribed that politician directly, if you've given that money to somebody else, and you know that money is going to reach the politician somehow, or that money is going to be used to bribe the politician somehow, that is still an offense. Now notice here, and this is something that you might be questioning, facilitation payments for routine government action are allowed. And this is one of the main highlights and differentiators of the US bribery law. You notice the word here, facilitation payments? You know, I think in the syllabus, CISI mentioned something about water and electricity payments, for example. You pay some official, certain amounts to, just connect this for me quickly, please. They also mentioned something about licenses, and visas. Pay somebody a certain amount to sort of, move it for you. The book, I do think if you're taking the exam that what we've highlighted in yellow is something that you should keep in mind. It's one of the main differentiators of the two laws. But I don't think that they are going to ask for examples, just the term routine government action. What it basically means: licenses, applications for water and utility, visas, for example. Defense is allowed if payment is lawful under written laws in the foreign country. And this is something that we're going to cover later. When we talk about mutual legal agreements or MLAs, where what I did might be considered illegal in your country, but it's legal in my country. So your law doesn't apply to me. Not in the UK. Not in the UK. If that is illegal in the UK, They don't care if it's legal in your country. You've committed a crime, and that law will reach you. Whereas in the US, you might say, well, you think this is illegal, but for us in our country, it's legal. So the US, this is a possible defense in the US. They cannot punish you because in your country, what you did is considered to be perfectly fine. Or if reasonable expenditure for demonstrating a product or meeting a contractual obligation. Like, I will give you certain money to come and see our products. I will pay you certain money to give us the time to demonstrate our product to you. In the US, that's fine. Listed companies must keep records and must have internal controls. Obviously, this is something that we all know. Actually, we encourage all companies, both listed and unlisted, to keep records and have internal controls. But listed companies, obviously, because they are public and they have international investors, this requirement is stricter. So the difference between the UK Bribery Act and the US one. Key differences, again, one question in the exam. The US Act covers only active bribery. So it is the person who pays. The US law does not cover receiving the bribery. The US law only covers paying the bribery. The UK law covers both passive and active bribery. The US law covers overseas bribery only, whereas the UK law covers both domestic and overseas bribery. The UK one does not allow facilitation payments, the ones that we said, the routine government payments, not allowed in the UK, but they are allowed in the US. In the UK, there are sanctions against companies that fail to prevent corruption. So you need to prove that you have active measures and controls in place to prevent bribery. Whereas in the US, such sanctions provide such sanctions for failing to keep proper records, not for failure to have policies and procedures. For individuals, of course, which we covered under section 1, 2, and 6. For individuals, the UK law provides a maximum penalty of 10 years and an unlimited monetary fine, whereas under the US one, a maximum penalty of 5 years and $250,000 per violation. As for companies, remind you, in the UK law, companies are covered under Section 7 of the Bribery Act of 2010. The maximum penalty is an unlimited fine for companies, because obviously you can't take the company to jail, so you can only fine it. So it fined unlimited amount, whereas in the US, the fines are limited to $2 million per violation. The main components when it comes to corruption and bribery. So we said, this is what we covered previously, and we said corruption is divided into bribery, into embezzlement, and into illicit enrichment. So we're just going through these now. So we start with bribery, and we said there is active bribery, which is paying the money, and passive bribery, which is receiving the money, even though in the US, the passive bribery is not punished. Embezzlement, we said that this is a form of theft of certain amounts where you are the agent or the guardian of it. A breach of trust, and therefore is a type of fraud. Because remember, the difference between fraud and theft, even though fraud is a type of theft, the difference is that fraud includes an element of dishonesty, an element of breach of trust. Since embezzlement, you're given a certain amount and you are an agent or a guardian of that amount and you embezzle it. That means you use it for a personal gain. You have breached that trust. You've committed fraud. a lawyer taking assets from a trust account of a client, because a trust account is an account where a client has given you a certain asset and which you're supposed to protect until the conditions of that trust materialize. So, for example, keep this money until my children are 18 and then give it to them. That's a trust. A fund manager taking funds of investors for himself. They trusted him with the money to invest it, and he embezzled it. A spouse, a husband or a wife, taking funds from a bank account held jointly with their partner without their partner's knowledge or acceptance. It's probably a reason for divorce, right? The main components of and differences in corporate practice, let's continue. Trade in an influence. A person misuses their influence over another for an advantage. For example, an official who claims to be able to persuade or order others to act to the benefit of the payer. Sort of saying, I'm the mayor of this town, what do you want? You want to get the principal of the school to accept your child? Leave it to me. Just give me $5,000. I'll talk to him. So I have influence, and I'm trading that influence for money. I'll talk to the principal of that school in return for the money that you're going to pay me. If you are just joining us now, please take a few seconds to type your full name in the chat room so we can confirm your attendance. Abuse of office. Holding a public office and abusing it for your private gain. I mean, it's more common than you think. Yes, in Africa, it's a bigger problem because, as we saw yesterday, a quarter of Africa's GDP is lost to corruption. But I mean, there's corruption in all countries around the world, but in third world countries, it's a bigger problem. To the point where the first world countries, the rich countries, have stopped giving donations and loans until corruption is fixed. So an example of an abuse of a public office, a public official performing or failing to perform an act with the intention to obtain an undue advantage. Again, the word of advantage. So you're acting in a way that gives you a certain advantage, or you fail to perform your duty without any reasonable excuse. So the public elected you into the office and you're expected to perform certain duties, and you are bribed not to do that duty. A judge was bribed not to go to court, for example. Abuse of office can also be seeking to interfere with the detection, investigation, and prosecution of offenses. Notice, so in the US, you hear this a lot, and they call it obstruction of justice. So even though you didn't commit the crime yourself, you are not the active briber, you are not the passive briber, but when the investigation was happening, you started putting obstacles in place so that the active and the passive bribers are not detected or caught. That's illegal. What is illicit enrichment? So we know that for many politicians, their salary is modest. For many public servants, their salary is modest. It draws attention when we start noticing them, living a lavish lifestyle, which could not be explained because your lawful income isn't enough for you to buy that 1 million dirham car. Well, if you can explain it, for example, someone rich in your family died and they left you money, then that's fine. There is an explanation. But if it cannot be explained, then you are going to be investigated. And it is not the responsibility of the law to prove that that was obtained illegally. No. The responsibility is on you to prove that you got it legally. Because this is something that's called the burden of proof. Again, something that is in law, something that is argued probably more than anything. So whenever you go to court, there's always the plaintiff and the defendant, and the court's trying to say, okay, what's happening here? Is the defendant responsible to prove that they didn't do it, or is the plaintiff responsible to prove that the defendant did it? Where does the burden of proof lie? Concealment can also be a corrupt practice, not making a disclosure, cover up. Concealing an offense carried out by a public office holder or a third party, could be active or passive concealment. Active means you are actively hiding something. You are actively putting obstacles in place to stop it from being exposed. Passive is not saying anything, not talking. That's still also considered as concealment. Mutual legal assistance. And we talked a bit about this, but let's dive a bit deeper. Let's say there are two countries, country A and country B, and there's a criminal who did something bad in country A, and it's considered a crime in country A. And then he runs away to country B, and he lives in country B now, and he is smiling. Just give him a smiley face. Why is he smiling? It's because what he did is considered to be perfectly legal in country B. So country A will will ask country B to send him back, but country B would say, well, what he did is fine in our country. He didn't commit any crimes. So that's why countries, country A and B, they go into agreements that we call dual criminality agreements, or sort of dual criminality. That means if he does, if he does a crime in A and he escapes to country B, then even if it's perfectly fine in country B, if country A and B have an agreement of a dual criminality, then country B will tell him, look, what you did was bad in country A, and country A and us, we have an agreement, so we're going to send you back to them. So they're going to send him back to country A, and he's going to go to jail. Obviously, we are going to give him a sad face. So dual criminality requires the action to be a criminal offense in both countries involved. No necessity for strict comparability as the basis of extradition. That means it is not necessary for strict comparability. That means you shouldn't say, if it's your crime, if it's a crime in your country, it must be a crime in my country. No. Now, if these two countries have a mutual legal assistance, or a mutual legal agreement, or a mutual legal assistance agreement between them, then this dual criminality becomes way easier. And mutual legal assistance refers to cooperation between states investigating the crime. So obviously, A can go to B to investigate the crime, prosecuting the crime, charging the criminal with the crime, obtaining evidence from country B, identifying and freezing the proceeds, and recovering proceeds of crime between both countries. And this is extremely important.